Hi, this is Rick Frederick talking about the case of Powell v. Texas, 1968. Powell and a case similar to it, Robinson v. California, are interesting in helping us understand how the Supreme Court thinks about insanity law as a constitutional issue. It's very clear that the Supreme Court, as a matter of due process and perhaps some other issues, considers there to be constitutional protection for competency to stand trial, that certain things must happen, but they don't see similar protections for criminal responsibility standards in federal law or as a matter of constitution. So in this case, Leroy Powell was drunk in public. He was fined $50. This was actually the result of a second trial. The first trial, he was only fined $20, but he pursued this, brought in an expert who said that he was a chronic alcoholic with a compulsion to drink, an exceedingly strong influence on his behavior. Now, the earlier case, let me just look at here, Robinson v. California, 1962. Robinson was convicted for being a drug addict because of track marks on his arm. Not for any behavior of his, but for having the status of being a drug addict. That's not what happened here. What happened here is that Powell was fined for his behavior, and what he's saying is that under Robinson v. California, he shouldn't be punished for that because the alcoholism was not anything that he could do anything about. So this case addresses issues of culpability with respect to medical and psychiatric conditions. So is it unconstitutional to convict an alcoholic for being drunk? Now, if you think about insanity law, is it unconstitutional to convict an individual with a psychosis who then does something psychotic? They can't help it. So the holding was no. So the question is it unconstitutional to convict an alcoholic for drunkenness in a public place? The answer is no. And the Supreme Court, if you read this case, they're very vehemently backing away from this notion, rejecting this notion, and a lot of good quotes came out of this. Okay, so what happened in this case? So Powell argued he was compelled to drink because of a disease, and essentially had an expert say he was powerless not to drink, even though he acknowledged that taking the first drink was voluntary. And so, these questions of free will, which are the essential characteristics or qualities of insanity, and we really don't have to get interested in the issue of whether alcoholism is a disease or not. But what the court says, look, this is fraught with problems because you could bring any number of psychiatric scenarios in which people said that they were compelled to act in a certain way, and it would be unconstitutional to punish them because of that. This is what the court is rejecting and saying there isn't a constitutional basis for an insanity defense. They have never stated that there was to this day, 50 years later. So what the court is saying, Robinson, we can't punish people for their status, having a mental disorder, but we can punish them for their behavior. And so some simple, some quotes from Powell, which are very helpful. Robinson stands for the simple but subtle principle that criminal penalties may not be inflicted upon a person for being in a condition, for being psychotic, for being a drug addicted, for being an alcoholic. You can't punish somebody for being in a condition that they're powerless to change. Another quote, the court has never articulated a general constitutional doctrine of mens rea. Actus reus, the behavior, mens rea, the intent. And the Supreme Court has always rejected this notion that this is something that they should get into. Nothing could be less fruitful for this court than to be impelled into defining some sort of insanity test in constitutional terms, okay, in terms of the Constitution. The question of whether act is involuntarily is elusive, and one which the state may wish to regard as irrelevant. So, if we were to take Powell, we would essentially require recognition of irresistible impulse as a complete defense to any crime. I couldn't help myself, therefore I can't be punished. Finally, I think maybe this is final, a form of the insanity defense would, if we found in favor of Powell, a form of the insanity defense would be made a constitutional requirement throughout the nation if the court should say it's cruel and unusual to punish a person afflicted with any mental disease whenever his conduct was part of the pattern of that disease and occasioned by a compulsion symptomatic of the disease. So Powell is not about insanity. Robinson is not about insanity. They are about different issues. But what is interesting in the discussion of the court in both cases is the rejection that there is any constitutional requirement to have an insanity defense. Currently, there's 4 states that don't have an insanity defense. It'd be very interesting at some point to see whether the court says states are required to have an insanity defense, which I don't think that's likely to happen. Thank you very much.